But item number 3, I am for the appellant, read by Mr. Jetmala Nimlad.
Lord, I am appealing for the respondent in this matter.
But there are two.
Lord, I am taking a point of maintainability
But there are two
as
ladies.
regards appeal.
But there are
Appeal maintainability, Lord, I am taking the points of maintainability of the appeal.
But there are two ladies before your lordship. There are two lady. Lord,
Where is the impugned order?
Lord, impugned order we have. Lord, it is with your lordship's brief memo. Stitch with the memo.
11th November.
Yes.
Just give us 30 seconds time.
Yes, my lord. Copy that.
আমাদের কপিটা ওই অর্ডারের কপিটা অর্ডারের কপিটা আপিল হয়েছে ইমেলি কপি
What has happened?
My lord, although my lord, we have challenged the investigational malafide.
Lord, I have a point, please. Lord,
18th November, where? 15 December.
no, that is orally.
Orally, it was
It was a notice, the date was fixed on 18/11.
18/11.
What has happened on
Then, my lord, we moved this applicable the appeal. My lord, verbally, Malayasi Chief Justice sitting with Malayasi Bhattacharya, my lord, they have passed a verbal direction that till 20th no action will be taken. It was a verbal direction. Now, my lord,
Not the no action, no, you will not be.
will not be, my lord, no coercive action will be taken.
Not the
Now-
verbal direction, my lord. It's a no. It's a desire of the court, and I agree to that.
Whatever my senior
No,
friend
that's
says,
right.
my lord,
But
I
my lord,
was
I have
not
a
there.
point of maintainability of the appeal itself.
my lord, I shall
Would your
satisfy.
lordship, my lord, hear the point of maintainability first or hear the merit?
point of
My
maintenance?
lord, this is latest patent appeal is not maintainable.
Why?
Against, my lord, the order, when an order has been passed by the writ court, really in a criminal jurisdiction. My lord, I am covered by one Supreme Court judgment and two High Court our High Court's judgment. Or is a criminal in nature, it has been said, when an investigation has been started.
Mr. Bandyopadhyay, what troubles me is whether the writ petition is maintainable or not is the writ
That is a different issue.
court who will decide it.
But now against that order
When order is
passed, whether no appeal is maintainable.
why not Article 15, the appeal is.
Latest, that is the point has been decided. Would your lordships kindly hear that? I can show the judgments and my lord, then, my lord, I will be personally happy if your lordships hold it. No, appeal is maintainable. Personally. But
Say the order is passed by a writ court.
by a writ court while exercised effectively in a criminal jurisdiction, criminal matters.
The point of maintainability is kept open.
Content of maintainability of the writ petition is kept open.
No distinction between a writ petition in a criminal side or.
No, writ petition criminal side is maintainable. Against that order, any order, appeal is not maintainable. Latest patent appeal is not maintainable. Correct. First, give it. Ramkrishna Fauji. First, your lordships
My lord,
kindly
my
see.
case will not cover.
No,
Under Ramkrishna Fauji,
Mr.
I shall
Majumdar,
satisfy.
will you kindly every time all you will speak?
Point the law point. He has the right to make some.
Yes.
Yes.
He will meet that
Yes.
this
Not-
argument. No
not-
Give us the chances now. Earlier we are not getting the chances. Now give us the chances to say. Earlier, unfortunately, we are not getting any chances. Now we are getting chances to speak. No. This no. This has to be said. This is no. Now we are getting chances. Earlier not. We were the other giant. No. First order that we have seen. None of them. You have not before your lordship's court. First, we will not prayer in the writ petition.
No, we are concerned with the appeal.
My lord, what is the nature of the writ petition? Lordships have to see. Then I will come. What is the nature of the writ petition? What is the relief has been asked sought for? Why patent? It is not maintainable. That I have to say. Lordships, kindly come to the prayers of the writ petition at page 55. Running page 55. B.
Yes.
Issue writ or in the nature of mandamus, directing the respondents as their main and agents are assigned to SOCO as to why the investigational proceedings. Yes, in connection with the Bhatpara police station case number 70 should not be quashed with respect to the petitioner's hearing, and if no sufficient reason is shown to quash the same for the ends of justice. This is the main matter. Now, my lord, whether it is exercising the criminal jurisdiction or not, writ court, that has to be looked into. My lord, kindly take this Ramakrishna, the judgment. Kindly take my lord Ramakrishna Fauji's case. This is my lord 2017 5 SCC page 533. First, lordships, kindly come to paragraph 4. Paragraph 4, kindly come to paragraph 8. Questioning the sustainability of the order passed by the division bench, Dr. Rajiv Dhawan, Learned Civil Counsel, has a singular contention that the LPA before the division bench was not maintainable, inasmuch as the Learned Single Judge at paragraph 8.
Paragraph?
8.
We were looking at paragraph 4.
Oh, all right. Paragraph 4, kindly come to paragraph 4.
Was not matching.
No. Kindly read the paragraph. At this stage, it is necessary to mention that the appellants had preferred civil writ petition number so and so, praying for a issue of a writ in the nature of statutory quashing of the impugned order dated 20th January 2014 and to 11th February to the passed by the respondent number 2. In short, by this order, directions for the criminal proceeding has been initiated. Then come to paragraph 8. Questioning the maintainability of the order passed by the division bench, Dr. Rajiv Dhawan, Learned Senior Counsel, has raised a singular contention that the LPA preferred before the division bench was not maintainable, inasmuch as the Learned Single Judge had exercised criminal jurisdiction. He has placed reliance on stands authorities to which we shall refer at the relevant places. Now, your lordships, kindly come to paragraph 18. On a plain reading, lordship, you have got it? On a plain reading of the aforesaid clause of the latest patent, it is manifest that no appeal lies against the order passed by the single judge in exercise of the criminal jurisdiction. Thus, the question that is required to be posed is whether the learned single judge, in the obtaining factual matrix, has exercised criminal jurisdiction or not. Then your lordships, kindly come to 21. It is worthy to mention here that clause 10 of the latest patent established in Lahore High Court, which is applicable to the Honorable Punjab High Court, is parameter with the clause 15 of the later patents of the Chartered High Courts. The 4th judges bench is so and so. Now, my lord, kindly come to paragraph 29.
Yes.
After so stating, the court elucidated the nature of criminal proceeding, and in that regard rules that Ishwarlal Bhavan so and so, a criminal proceeding, on the other hand, is ordinarily one in which it is carried out to its conclusion. It may result in the imposition of sentences such as death, imprisonment, fine, forfeiture of property. It also includes proceedings in which is the largest interest of the state, orders to prevent apprehended breach of peace, orders to bind down persons who are a danger to the maintenance of peace and order, aimed at preventing vagrancy of the contest so and so. Then 30. The character of the proceeding in our judgment depends not upon the nature of the tribunal, which is investigated with the authority to grant relief, but upon the nature of the right violated and the appropriate relief which may be claimed. Then kindly come to paragraph 31. The aforesaid authorities makes a clear distinction between civil proceeding and criminal proceeding. As far as criminal proceeding is concerned, it clearly stipulates that criminal proceeding is ordinarily one which, if carries to its conclusion, may result in imposition of sentence, and it can take care with its ambit the larger interest of the state, orders to prevent apprehended breach of peace, and orders to bind down the persons who are a danger to the plaintiff's defense. The court has ruled that the character of the proceeding does not depend upon the nature of the tribunal which is invested with authority, but upon the nature of the right violated and in the appropriate relief what may be claimed. Then, Milord, kindly come to this paragraph 32. 32, Milord, one paragraph has been quoted from one judgment, Milord, 92. Sorry, 92. The position which emerges from the above discussion is that under clause 15 of the latest patent of the Chartered High Courts, from the judgment within the meaning of the term as used in that clause of a single judge of the High Court, an appeal lies to a division bench of that High Court. And there is no qualification or limitation as to the nature of the jurisdiction exercised by the single judge, which passing his judgment, provided an appeal is not barred by any statute, for example, 100 of the Code of Civil Procedure, and provided the condition laid down by clause 15 itself are fulfilled. The conditions prescribed by clause 15 in behalf of that is, it must be a judgment pursuant to section so and so, judgment so and so. Then 100. According to the full bench, even where clause 15 to apply, an appeal would be barred by the express words of clause 15, because the nature of the jurisdiction on article 226 and 227 is the same inasmuch it consists of granting the same relief, namely scrutiny of the records and control of subordinate courts and tribunals, and therefore the exercise of the jurisdiction under these articles should be covered by the expression revisional jurisdiction and power of superintendence. We are afraid the full bench has misunderstood the scope and effect of the powers conferred by this article. These two articles stand on an entirely different footing. As made abundantly clear in the earlier part of this judgment, their sources and origin are different, and the models upon which their pattern are also different. Under Article 226 of the High Courts, including any have a power to issue directions order under so and so for any person of so and so. Article 226 of the High Court has power of superintendence over all courts and tribunals throughout the territory in relation to which it exercises jurisdiction. The power to issue writ is not the same as the power of superintendence by no stretch so and so. Then we'll kindly come to paragraph 47. Dwelling upon the said issue, the court in Ganga so wherein the court had categorized the certain aspects of the case as illustrations, wherein power under Article 226 or the inherent power under Section 482 CRPC can be exercised. We noted the court gave a note of caution to the effect that the power of coercing a criminal proceeding should be exercised very sparingly. So, this is not more relevant here. Kindly come to paragraph 51. It is worthy, my lord, got it? It is worthy to note that a series of decisions were cited on behalf of the appellants herein, including full bench judgment of the Gujarat High Court, Patel so and so, wherein the full bench considered Article 226 and 27 in the Constitution in the light of the various decisions of the court and deduced certain principles. The division which Sanjeev so and so distinguished this decision on the ground that full bench did not lay down as a proposition of law that LPS would be maintainable even if an order was passed by the learned single judge in exercise of the criminal justice so and so. 80. In our considered opinion, in the instant case, the proceeding can be said to be criminal proceeding, inasmuch as carried to its conclusion, they may result into imprisonment, fine, etc., as observed by the Supreme Court in Naran Rao case. From the totality of the facts, we have no hesitation in holding that a learned single judge has passed an order in exercise of criminal jurisdiction. At the cost of repetition, we reiterate that we have already stated earlier that the proceedings were of a criminal nature. Whether a criminal court takes cognizance of an offense or stands compliant to so and so, and it does not make a difference so far as the nature of a proceeding is concerned. Even a cognizance is not taken. That fact would not take out the case from the purview of the criminal jurisdiction. In our judgment, a proceeding under Article 226 of the Constitution arising from an order passed or made by a court in the of the under the Code of Civil is still a criminal proceeding with the meaning of clause 15 of the latest patent. A proceeding seeking to avoid the consequences of a criminal proceeding under the Code of Civil will continue to remain a criminal proceeding, covered by the bracketed portion of clause 15 of the latest patent. Then we'll kindly come to paragraph 52. From the aforesaid analysis, it is demonstrable that the Gujarat High Court has opined that relying upon the authorities of the issue whether proceeding are civil or not would depend upon the nature of the right violated and appropriate relief which might be claimed and not upon the nature of the tribunal which has been investigated to grant relief. The division bench further opined that if a cognizance is not taken in respect of a crime, it would not take out the case from the purview of the criminal jurisdiction. Thus, it has been held by the division bench that when there is a proceeding under Article 226 of the Constitution arising from an order whereby could issue a power under the Code of Criminal, it would be a criminal proceeding within the meaning of the latest patent. Then Miller kindly come to 56. As we find out from the decisions of the above three high courts, it is evident that there is no disagreement or conflict on the principles that if an appeal is barred under clause 10 or clause 15 of the latest patent, as the case has held that whether the power is exercised on Article 220 of the Constitution for quashing of a criminal proceeding, there is no exercise of the criminal jurisdiction. It has been distinguished proceeding for quashing of the FIR under 482, and that context has opined that from such an order, no appeal would lie. On the contrary, the high courts of Gujarat and Delhi, on the basis of the law laid down by the so-and-so, have laid emphasis on the seat of initiation of criminal proceeding. The consequences of a criminal proceeding are also the nature of the relief sought for before the single judge under so-and-so. The conception of the criminal jurisdiction as used in clause 10 of the latest patent is not to be construed in the narrow sense. It encompasses in its gamut that inception and the consequences. It is the field in respect of which the jurisdiction is exercised is relevant. The contention that solely because a writ petition is filed to quash an investigation, it would have a room for intra-court appeal, and if a petition is filed under such inherent use under Article 42C, there will be no scope for intra-court appeal, would create an anomalous, unacceptable, and inconvenient situation. The provisions contained in the latest patent does not allow or permit such an interpretation. When we are required to consider a bar or non-permissibility, we have to appreciate the same in true letter and spirit. It confers jurisdiction as regards the subject of the controversy or nature of proceeding, and that subject is exercise of jurisdiction in criminal nature. It has nothing to do whether the order has been passed in exercise of the extraordinary jurisdiction under Article 220 of the Constitution or inherent jurisdiction of under Article Section 482. For this regard, an example can be held in similar in 58. In view of the aforesaid premises reason, we hold that the High Courts of Gujarat, Delhi have correctly laid down the law, and the views expressed by the full bench of the High Court of Andhra Pradesh is incorrect. Then Miller kindly come to paragraph 60. On the aforesaid basis, the division bench in the proceeding on Article 2 consisting of civil rights, the proceedings are civil in nature, falling within the ambit of clause 10 of the latest patent. In the said case, the detention was under the copy posa. The court observed that the said detention is purely preventive without any trial in a criminal court, and the challenge to such detection is for the enforcement of the civil right, fundamental, and therefore read under Article 2 for issue of a so and so has been a this is the distinguishing point. Then kindly come to paragraph 62. In view of the aforesaid premises, prismatic reasoning, the irresistible conclusion is that the latest patent appeal was not maintainable before the division bench. Consequently, the order passed therein is wholly unsustainable, and accordingly it is set aside. However, as the state had been diligently agitating its grievance in a legal forum, which is thought the jurisdiction, we grant liberty to the state to avail the order of the learned single judge so and so. Now, next, there are two judgments of our high courts. First one is that, Miller. Citationটা বলে দাও। Miller 2020 SCC online Calcutta 755 division bench judgment presided over by the Chief Justice, the then Chief Justice. Let's straightway come to paragraph 21. Having considered the aforesaid three decisions and several other decisions, the Honorable Supreme Court held that High Court of Gujarat and Delhi have correctly laid down the law, and the view expressed by the full bench of the Andhra Pradesh High Court is incorrect. The Honorable Court also observed that the conception of criminal jurisdiction as used in clause 10, which is parameter with clause 15 of the latest patent, is not to be construed in a narrow sense. It is not this practically quoting from that judgment, paragraph 22. The facts of the case of Ramkishan Fuji are different from the facts in the present case. In that case, the learned single judge order had consequence which was clearly criminal in nature. The learned single judge opined that the recommendation of the lockout of registration of awyer ekhane Ramkrishan Puji's case. Now kindly come to
Reading. Reading the.
Milord, kindly yes. Well, just few lines kindly skip. First, second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th, 11th, 12th. 12th line from the bottom of that paragraph. Reading the Honorable Supreme Court decision in the case of Ramkrishan Fuji as a whole, we cannot accept the contention of the learned senior counsel representing Gopal that if the High Court in exercise of the power under Article 220 of the Constitution passes an order which has even the remotest connection with the criminal case, then the order must be said to have been passed in exercise of a criminal jurisdiction, notwithstanding that the order by itself does not have any criminal consequences in the sense that it neither directs initiation of a criminal proceeding, which may have penal consequences for the accused person, nor it directs quashing of the termination of a criminal proceeding, thereby relieving the accused person causes so and so criminal, thereby relieving the accused person of possible penal consequences. In our concept, the decision of the round does not advance the case of the writ petitioner on the point of maintainability of the appeals. Then, Miller, the other paragraphs have been quoted. Then kindly come to paragraph.
Para 27.
Para 27. We have no disagreement with the proposition of law propounded in the aforesaid. However, in the facts of the present case, learned senior neither resulted in initiation of the criminal proceeding nor in quashing of the criminal proceeding. The facts of the incident are different. Here, the criminal proceeding is in question. Now, Miller, kindly come to another judge. They are paid for quashing of the proceeding. Now, my lord, kindly come to another judgment. That's my lord, my learned friend appeared in that matter. All we preferred appeal, including states, in Subhendu Adhikari's matter. That is, my lord, in short for my lord, the quashing of the criminal proceeding. And there, my lord, the interim orders were passed. Number of persons, including state of West Bengal, also preferred an appeal against that order. Lordship got it, my lord? That kindly come, I will not take much time to your lordship to finally read this paragraph, my lord. Last page 16, kindly come. All the judgments have been considered, my lord. In that case, challenge was quashing of the criminal proceedings, interim orders were passed. We, state of West Bengal, preferred appeal. State of West Bengal preferred an appeal, right? State of West Bengal preferred an appeal. That appeal has been dismissed on the ground that no, latest pending appeal is not maintainable. There was for the state of West Bengal, we want to know, what is the law then? In one case, when I will come, not maintainable. When he will come, it is maintainable. It cannot be the law. Therefore, it is not maintainable. Held it, that the primary reliefs granted by the Honorable Single Judge pertain to the exercise of criminal.
Case of this Gopal Kumar Agarwal, it was said as maintainable.
Yes, because it was transferred.
Because it was a transfer of investigation. If a transfer of investigation is there, it is maintainable. Not initiation or quashing.
And what has been held here?
In Subhendu Adhikari's case, they sought for quashing of the criminal proceeding. They got an interim order. Against the interim order, private persons and the state of West Bengal also preferred an appeal. Then this division bench of the Calcutta High Court has held, no, it is not maintainable. See, my lord, last A, that the primary reliefs.
According to because the clause 15 of the latest patent says that an appeal would lie against a judgment, provided it is not passed by a criminal
Jurisdiction.
a criminal jurisdiction. So if you say that criminal jurisdiction means even if the writ is filed, but the object and the purpose has to be seen. And if the primary relief which is claimed is the quashing of an FIR, then in that event it is really an exercising the criminal
Criminal jurisdiction.
under the writ jurisdiction. And therefore, embargo is created and the clause 15 of the latest
Latest
appeal is
petition.
not maintained.
But after this
Fauji's
Ramphouji's judgment, but I will be personally happy, I tell your lordship, if your lordship hold it to maintainable. But because of these judgments also,
Yes, my lord,
maintainability.
it's a my lord distinguished feature in our case. My lord, in our case, your lordship will see the prayer. Petition number 1, she is not an accused. We did not pray for termination of the proceeding or initiation of the proceeding.
You ask for a quashing of the.
No, quashing of the investigational proceeding where my right under Article 21 has been infringed.
Quashing of the.
Investigational proceeding, my lord. I have never prayed for proceeding. Kindly see the distinguished, my lord.
Why the investigation?
Yes, because I have been given a notice under section 160. 160, your lordship knows better than me. It's a notice given to a witness. We have challenged that notice before this court, my lord. And that is the way, my lord, that I am saying, my lord, it is infringement of fundamental right under Article 21, which is a civil consequence. That is the reason this, my lord, the appeal is maintainable. I shall, my lord, place one by one. I shall distinguish all these judgment and place, my lord, the relevant facts of this case. Your lordship will understand how the malafide investigation is going on in respect of the petitioners only. My lord, I am not praying for quashment of the entire FIR or entire charge sheet. I am saying the investigation, so far as the present petitioner is concerned, it is bias and malafide. And section 160 notice is bias, the outcome of biasness and malafide, my lord. That is my submission. That has a civil consequence under Article 21 of the Constitution. This is my submission. I shall satisfy your lordship. If I place the facts of the case, your lordship will be, my lord, everything will be clear. May I, if your lordship, my lord, permits me, I can place it also now.
First thing is you will have to make a distinguishing.
Yes, I can. My lord, I can. My lord, kindly see. My lord, our case is completely different. Completely different. Here, my lord, I have not prayed for quashing of a, my lord, proceeding or FIR or charge sheet. My lord, I said in my application, the proceeding qua the petitioners. It's malafide and it is infringement for violation of Article 21, which has civil consequence. The same principle has been reiterated in Ramkishan Fauji's case also. Gopal Agarwal also, it was a habeas corpus application where there is illegal detention, infringement of Article 21. There, their lordship has held this application, the writ is maintainable. But I shall argue on that line only.
Yes. You will argue or your senior will argue.
Lord, if he is not available, I shall argue. I have no difficulty, I am ready with the matter. But he was waiting, I kept him waiting now, somehow the matter could not be taken up.
Tomorrow, come
but
tomorrow.
tomorrow I have difficulty.
I am ready.
I have cancelled my program since yesterday. They have taken time. Today, yesterday I was. Tomorrow, day after tomorrow. I don't mind.
Till both of you ends.
But I am ready. My flight is 6:45.
That is what I am saying.
My
Your
flight.
party is already there.
My flight, and in the night, the last day I was arguing a matter.
Ask to put one. Friday we can keep.
Yes. For this, no, please. For this matter, because since it was yesterday, I came day before yesterday night at 3 a.m. in Calcutta.
At 3,
But they had taken time, I have
at
said.
2, I have some difficulty. If you can keep it at 3, I can.
3 I have matters. In the morning, then 3.
Morning, I have no difficulty.
3 p.m. my matters.
Morning, I have no difficulty.
Friday. 3 সময় আমার মামলা ফিক্সড আছে।
Okay, sir.
Any problem? Take this matter on Saturday.
Problem is not with me. Problem is
Of course.
My brother has to go to NJ.
Oh, my lord will come back.
There is all
My lord will.
there. All the programs in
Saturday, Friday when
Judicial Academy.
Friday is problem.
Is from Friday, Saturday, and Sunday.
Whole day will be there.
National Judicial Academy.
And that will be at National Judicial Academy.
National Judicial
Oh,
Academy is Bhopal. Not here.
MP.
Otherwise, your lordship has to leave tomorrow.
Monday, Tuesday, my lord, Monday, my lord, I have some personal difficulty.
No,
Tuesday.
from
Any time your
25th,
lordships feel.
from 25th, I am having this session. Then in that case, make it a Friday week, I will come back. Tonight.
Well, Monday, what difficult?
My session will start, my parliament session.
Monday,
Any Milord, I will skip one day from the parliament, I can come on Friday, Milord. In the midst of the week, it's difficult. 25th, I have to go.
what Friday then?
I have no problem. I have no problem.
সকালবেলা, which time is convenient to both?
Friday.
Coming Friday week, sir.
Friday week, you will also fix it anytime. Milord. I have.
My brother is not there.
No, it's all right. Anytime. Anytime.
Anytime.
Anytime.
I have to come back, that's why.
I will come back on Thursday night. ভাই আমি কিন্তু পারবো না আর করতে তাহলে না তুমি যেভাবে ইচ্ছে টাইম না দেখলাম কোনো অসুবিধা নেই। আমি পারবো
Because I do not want to disturb the other in the morning at 10:30 first matter
Yes, yes. I
on
have-
Friday week.
on Friday.